So use a simple, straightforward flow, avoid repetition of words and phrases, observe normal rules of grammar. Doesn't matter if your grammar is not so good. So if you make some grammatical mistake, nobody is going to question you about that. So we have again a very distinguished former judge who says brevity, simplicity and clarity. We have three things. Don't write too much. Brief, simple English and clarity. Clarity not only of language but of thought. What are you trying to communicate? Similarly, you have to take an objective view. Unnecessary criticism, use of harsh language, like I said, non-application of mind. That used to be a regular phrase when I was in AC. Used to hear this from all our superiors, non-application of mind. What is non-application of mind? It's a subjective decision. What a person who is highly intellectual, how he does it, or a person of mediocre intellect, most of us fall in that second category. We apply our mind to the extent we are capable. Now, what are the merits of speaking orders? One is accountability. You are public servants, you are accountable, not only to the government, to the public. Secondly, transparency. Half the problem with government is that we do not explain why we have done something. Transparency comes when you bring it out in the open. Yesterday, Mr. Kennedy spoke to you all. One of the first attempts where government tried to explain why we went in for the negative list. He brought out a, what's it called? One of the best things that we could have done. I'm not saying that was perfect, but there was an attempt to explain what is negative list. And even today, I find also citing those chapters. For instance, intermediary. What is an intermediary? Go back and read that book. This is something that we should do. Transparency in government. Guards against allegations of corruption. If you pass a vague order or an order which does not give a reasoning why you arrived at that decision to drop the demand, somebody tomorrow can say that you had some other interest in it. Yesterday, Samyukta had mentioned some of that. Pecuniary interest, personal bias. These are the types of influences which can be alleged if you are not able to communicate the reason why you came to that decision. Your reasoning may be wrong, but for you, if you are satisfied that this is the reason I passed this order, in most cases, the reviewing authority will not take it adversely against you, and neither will the taxpayers. Taxpayer also wants something where if he will, even if he is not happy with the order, he wants to know so that he can go on appeal on those points. If your order is itself not comprehensible, it becomes difficult for him to go on appeal. So look at that point. Clarity reduces arbitrariness and bias. Arbitrary orders. I'm not in a good mood today, so I'll confirm all orders. Tomorrow I'm in a good mood, I'll drop all the orders. There's no logic. Adjudication requires time. I agree with you.
There was a study in US. How mood of the judge affected the order on a particular day. Same judge delivering different orders on identical cases. It was Daniel Kahneman in Noyes book. He has described so many examples on that.
So one day, I did it when I was in AC. Which was Saturdays, I would not meet anybody. So I used to go sit in my office, which was a haunted building. Both of us have worked there. Saturdays, I would not meet anybody. And I would sit and write the orders myself. I didn't have a steno. So writing orders by myself, all by myself, I found I could think better logically. Otherwise, what happens is you start writing after one paragraph, sir, commissioner is on the line, or somebody else is calling, you lose your flow of thoughts. You forget something. So sometimes you have to take time off to do it. I know it's difficult, but you can. And always write your orders. Typing, if you have good typing skills, fine. Otherwise, please write out your orders. My experience is when you write, the logic flows correctly. Because you take time. When you use this computer, sometimes the computer jumps your thoughts much faster than your thoughts. Even today, before you finish a sentence, the computer finishes the sentence for you. And you may not notice. We have had problems when we transited from non-computer days to computer days. One budget I remember, all the notifications were ready. The government resigned. 2-3 days before the budget, the government resigned. Maybe before your days. And after 2 months, there was an interim budget. So we were very happy. I was a technical officer. We were very happy and not everything is ready. Notification, proposal, we'll just, recycle it. We not bother too much. So everything got cleared again by the new FM. Notifications were ready. And those days, you boys will not understand, the youngsters here, we used to cyclo-style it. There was no photocopy. We used to cyclo-style all notifications and deliver it by hand to every commissioner. So, just before we send it out, and the budget speech is about to start, we have a practice of sitting and reading each other's notifications. Suddenly, something struck me. Everything is correct. Even the year was corrected, but the date was not correct. And all the notifications. The whole cut, paste, cut, paste. So finally we realized we had to redo the whole thing because of cut, paste. So please do not accept cut, paste in orders original at least. At least apply your mind and do it. It also makes judicial review faster. Because if you have put all the facts logically, all the conclusions logically, the person reviewing the order need not run around to look at books and look at what other section he was talking about. It creates awareness about the problem. One of the points which was mentioned yesterday also was a consultation before issuing a show cause notice. Right? You consult a party before issuing a show cause notice. One of the reasons for that is, if you are convinced that a department case is strong, if you can convince him, his grievance comes down immediately. If you are not convinced yourself, you cannot convince the other party. And once you convince them, their grievance comes down. They know, okay, your hands are bound, you are supposed to do this. They don't hold it personally against you. So pre-consultation or any consultation is fine. It gives a measure of satisfaction to the affected parties that justice has been done. How does he know that justice has been done? By reading the order that you issue. I know that many cases today, even in customs, all that, we all become faceless. SSC doesn't know what's going on in your mind. He's only reading whatever you have done. Right? So please make it more open. In fact, in the training that we hold, not only in the university but in NACN also, one of the new ways compared to the last 10 years is concept of good governance. Government always talks of good governance. What is good governance? Good governance is that whatever the government does should be clear, transparent, predictable. The public should know what the government is doing, why it is doing, and what he can expect. In tax law, it is even more important. Because a change in the law a change in your approach can shatter his business. Which was mentioned in the morning, that indirect taxes. By the time you make up your mind, by the time you pass an order, he's already sold his goods, his supplies are over. Now, where is he going to recover it? Now, some people were saying that the time period is short. Time period is short because it's a problem for the taxpayer if I keep it pending for 10 years, 15 years. There are even today tax laws in India where assessment can be reopened. Even after 8 years, 9 years, I can reopen your assessment. We didn't want that. That is why if you see the GST law, you have to decide the case. Even in the worst cases, you have to decide within 5 years. You cannot keep it open beyond that. The call book has been cremated. You don't have, I hope you people don't have the call book yet.
No, sir. It has been resurrected in the GST law by virtue of section 7511. I have forgotten to mention to them about 7511. What does it say is any decision taken on which the department has filed an appeal, we is to take the subsequent issues of the same taxpayer into call book. In GST law under 7511, what it says is if the department filed an appeal on an issue and a similar issue is pending on another taxpayer, so the notice issuing period will exclude the period of limitation for the time taken by the appealing authority to the decision making authority. That times will stand excluded for the purpose of computing the time limit for issue of notice. In a way, call book has been legalized in 7511.
That for entry of call book, this was introduced, it was not there in the model law.
No, this was all done subsequent, sir. When we submitted our subcommittee report, it was not there.
I'm totally opposed to what has been done, but anyway, if it is there, it's there. But anyway, what I am talking about here is good governance. Your orders are also part of good governance. That's why I said this does not apply only to tax demands or tax penalties. It also applies to administrative orders. Where even our own officers are involved, where you take vigilance action, disciplinary action, explain what you are doing. I still remember in those days when we went in for liberalization of tax, second half of 1990s and early 2000. One of the officers came and asked me, sir, you fellows at TN are doing so much to liberalize tax. Why don't you do the same for us in the department? I found it a very genuine question. So keep these in mind. I just tried to explain what is the emphasis of good orders, how it should be drafted, how it should be issued. Now I'll cut short. The reason is before Vinod Kumar sir leaves, we had a similar workshop on adjudication in Delhi, in the Center of Excellence in Delhi, where we had officers from 4 or 5 states and central government. After that, the CUE brought out a handbook. All the aspects of adjudication. If you don't have a copy, please NACN can.
We have a soft copy.
Please, sir.
You can send the link to all the participants. You can read it whenever you get time.
Thank you so much. Thank you so much. Thank you, sir. In respect of taking things from the other department, using your PAN number, our own PAN number, we should know their IE code and also. Right now, we are not aware of the IE code of the other person using their PAN number. It was not disclosed in the website of the CB. So previously,
you can explain.
Previously on a PAN number, if a PAN number is placed, it was 2-3 years back when it was bad period was there. With a PAN number, we can get the IE code of an individual or an office, a company with a PAN number. Right now, it is not possible for us to get an IE code of
You are working in GST or customs or what?
GST, is a state GST. Somebody in their profile, they won't disclose IE code, sir. If the IE code is available, it will be very useful for us to know whether he has imported or exported something. We can do that, sir.
Basically, you have access to the e-way bill data. In the taxpayer profile, they are not indicating the IEC code. I'll tell Mr. P.V. Butt to include it. The database is available. IEC code is basically issued by the DGFT. It is also PAN based. Right? IE code is required to be disclosed in the bill of entry for the purpose of the shipping bill for the purpose of import export. Since both GST registration number as well as the IE code is basically coming from the PAN and the database is available, it's available for example, the custom officer sitting in the port. He will have the moment the IEC code is given, the PAN is there, the registration is disclosed, where registration is also required to be mandatorily disclosed to know how the IGST flows from the custom system to the GST system. Your need is just IEC code should be displayed in the GSTN database for you. Note it down.
Sir, I have a technical question in the sense from the previous era to this era. I would like to know what is the difference between not levied and short levied and not paid and short paid. So that's the first part of the question. And why I'm asking this, why this question is triggered is precisely because under section 11A of the Central Excise Act, we had that provision for determining not levied and short levied, whereas under 73, we don't have not levied and short levied.
We are talking about short paid, not paid, but not the levy part of it. That's what we are talking about. See, basically, these terminologies have historically evolved, as you rightly said. See, in GST, basically the levy is under section 9, right? Section 9 provides for a comprehensive manner in which how the levy and collection happens. Particularly, you can look at from the point of view how Central Excise Section 3 was worded and how Section 9 of the CGST Act has been worded. So, in Section 9, we are talking about the taxable event called supply. We are talking about the valuation, which is covered under Section 15, which we will not find in Section 3 of the Central Excise Act. We are talking about the time and manner in which it is required to be paid and collected. Right. We have comprehensively covered everything in Section 9 vis-a-vis what was there in Central Excise. It's an evolving era. While levy and collection is statutory and it is actually embedded in the source law, the manner of collection could be a matter of detailing for the administrative authorities. While the machinery provision of determining the tax not paid, short paid, we have considered that this not paid, short paid will have to be read in conjunction with Section 9, which already provides a detailing part of it. So probably I think at the time when we have drafted it, we thought that since levy is already built in comprehensively in Section 9 CGST and Section 5 in IGST comprehensively covering taxable event, measure of value, person liable to pay tax and the manner in which it has to be collected, probably repetition was not thought of. But whether it is non-levy, short levy, which results in short payment or non-payment, the fundamental what we have to keep it in mind, it is the tax which otherwise required to be collected by the government, stand not collected on account of the short payment or non-payment. A levy can even go to the extent of determining whether it was covered by the law to be collected or exempted from payment and tax, etc., could come into. That's the only possible reason I can think of, but it doesn't substantially alter the way in which Section 11A has been drafted vis-a-vis the GST law has been drafted. My only plausible explanation as to why we have not included the short levy, non-levy in Section 73 or for that matter 74 is basically because our levy and collection section in Section 9 has been comprehensively worded. We not only cover levy and subsection 1, we talk about the obligations which are otherwise fastened under the Finance Act under 68(2) with regard to reverse charge where person is made liable. 9.3, 9.4, 9.5, if you look at it, we have comprehensively covered even the person who is required to pay tax in the manner in which he is required to pay tax.
So I think probably that's precisely because of the fact in Finance Act 73, Section 73 also does not have this word short levy, non-levy. Probably that
basically I think that's an evolution. This one.
Yes. Okay. Sir, one more final question on the procedures. I have issued a show cause notice. I have confirmed an order which carries both SGST and CGST part. While confirming it, I had combined it and said that total liability is 1 lakh rupees, where I should have mentioned it as 50,000 rupees as CGST and 50,000 rupees as SGST, which I failed to mention in my order. Can I issue a corrigendum to that and say that 50-50 should be read, 1 lakh should be read as 50/50?
Yeah, provided your show cause notice had made that classification separately while demanding
And
it.
in
and you
your
passed an order.
findings,
Yeah.
when you came to the, before you came to the final part of your order,
Yes.
you would obviously have discussed the quantification.
It can.
There, if you have done that, then there is no issue on that.
You can do.
But corrigendum, as I said, corrigendum also depends on when you issue it. Not after 1 year, 2 years. No? When somebody comes, some review section and you say, okay, I'll issue a corrigendum, that's got no value. But that is why I said, if your reasoning is correct, and then the decision, you have combined the two, well, your annexure to the show cause notice we discussed yesterday, the annexure is also linked to the show cause notice, the calculation sheet. It is not my views on this matter, it is the decision of the Supreme Court. So probably you can have a look at that. Go to the very end. Go to the last slide. Yeah, that's it. What is the disciplinary action that can be taken based on the officer who has passed an order? This is what the Supreme Court has said. Where the officer has acted in a manner which would reflect on his reputation of integrity or good faith or devotion to duty. If there is prima facie material to show recklessness or misconduct, if he has acted in a manner which is unbecoming of a government officer, if he had acted negligently or omitted the prescribed conditions essential for exercise of statutory powers, and you are exercising statutory powers under GST or customs, if he has been actuated by corrupt motive, however small the bribe may be, as one of the old British judges say, though the bribe may be small, the fault is great. The instances catalogued are not exhaustive. Each case, they say, should depend on the facts and circumstances. This is a 1999 order of the Supreme Court. So we cannot disregard these guidelines. These are the guidelines that should be followed. Many of you will become very senior soon. So when you read an order, apply these guidelines before thinking of referring to vigilance section. Okay. With that very positive thought, thank you very much.